webinar, which I think is really our best, my most interesting topic, defending claims. We have two experts that are going to be joining us, both who start the claims process for you right from the start, and probably follow through till the end also. So we're going to hear from them when I'm done with my opening remarks. What should you do when you are aware of a possible claim? I know you can see my screen, and I've written them out. I'm not going to really elaborate, but you secure your records, not just yours. Make sure you contact your central station, or if you have any subcontractors that have worked on the job, get their records. Do an internal investigation. That means talk to your operators, if you're a central station, or your service people. Find out what they have to say about the potential issue, a repair question, or a installation question, or monitoring question. Reduce their remarks to writing. Have them sign it and date it, and preserve it in your claims file. Also, immediately notify your broker and your insurance company. Keep in mind that notifying your broker is not the same as notifying your insurance company unless your broker happens to be an agent of the insurance company, and in most cases, that broker isn't an agent. So you need to make sure you've notified the insurance company. Either you or your broker can do it, but you have to make sure that it's taken care of. Look at your policy. There's a paragraph in there that tells you what to do if there's a claim, who to send the notice to, and that's where it has to be sent. If your broker sends it for you, ask for a copy at the time it's sent out. The notice always starts with, this is your first notice of this claim, and you need to make it clear that it's also your first notice of the claim. You do not admit to knowing about a potential claim way back when, because it was really your duty to notify the carrier when you thought there was a potential claim. You might hear that you don't need to do anything until you actually get a claim, a nasty letter from either the subscriber or its insurance company or someone else. My recommendation to you is that if you know about a potential claim, it should probably be reported, especially if it's a significant claim. Now, keep in mind that claims that are within your deductible range, there's really no point in reporting them if you're sure that they're going to stay within your deductible range. If there's a possibility that it could mushroom well beyond the deductible, then you want to get your carrier involved. Receiving a summons sometimes is the first notice you have of a claim. Maybe you're not even aware of a loss, which is not likely, but it's possible. A summons must immediately be sent to your insurance company, and you should make sure that you are in touch with the claims representative, talk to that claims rep, and try and get them to pay attention to your claim right away so that you know it's being handled. Recently, there was a case where a default was taken against, it wasn't an alarm case, but against an insured who said he sent it to the summons to the insurance company. They didn't answer in time. Well, that doesn't always help you. Probably the insurance company is going to be responsible for it, but if they end up with some other kind of disclaimer, you have a problem on your hands. Make sure that your claim is being handled. You're going to get communication from your insurance company once you've filed a claim, whether it be a summons or just a claim letter. There are basically 4 different things that carrier can do. 1, accept coverage, and you're pretty much, there's nothing you need to do at that point, initially anyway. The carrier can deny coverage, and they'll tell you why. It can accept coverage with a reservation of rights, and it can accept coverage with notice of an excess claim, which is also usually within a reservation of rights also. So denial of coverage, what are your options? You need to defend that case yourself at that point, and you can start a lawsuit against the insurance company. It's for declaratory relief, and you're looking for a declaratory judgment that the carrier is obligated to defend you. In New York, the law is that if you sue the carrier and win, you're not entitled to your counsel fees. If the carrier sues you and you win, you are entitled to your counsel fees. So sometimes there's a cat and mouse going on to see who's going to start that lawsuit. Really, a carrier acting in good faith should be the one to start it. In the meantime, however, you must hire your own counsel and protect yourself in the lawsuit that's been started, or respond to a claim letter if that's all you have at the time. Reservation of rights letter needs to be reviewed, and often you need to take some action. Some brokers may tell you, or you may be of the impression that reservation of right letters are something that's just routine, sent out, and don't worry about it. That's not the case, especially if there's a serious claim. You need to read that reservation of rights letter and understand why it was issued, and sometimes you need to do something about it. If you receive a reservation of rights letter in some jurisdictions, meaning in some states, it then gives you the right to select the counsel you're going to use. The reason for that is that if there's a reservation of rights, that means that you and your own carrier are in conflict, because some of the claims may be handled, meaning defended and paid, the indemnity end of it, and others not. Incidentally, I should point out that in all jurisdictions, your right to a defense is far broader than your right to actual indemnity under your insurance policy. So that's why these reservation of rights are sent out, because the carrier isn't able to deny coverage altogether. So they say, we're going to have to defend you, we're going to pay for your defense, but at this point we're reserving our right not to pay any claims that might get issued against you or awarded against you, and that's the reservation. Oftentimes there's different causes of action against you for the same loss. Maybe it's a contract action, it's a tort or negligence action, and the carrier may say to you, we're going to cover the tort action, but we're not going to cover your contract action. So when they hire a lawyer, you need to make sure that the lawyer doesn't steer that case to the cause of action that the carrier doesn't have to pay out on. Now, in all jurisdictions also, the lawyer hired by the insurance company is your lawyer, meaning he owes his duty to you, but as a practical matter, his check's signed by the insurance company, and his next case is coming from the insurance company. So I would be a little leery about the assurance that the loyalty is owed to you. But that is the, I don't want to say fiction that we all operate under, but that's the way that works. Sometimes the reservation of rights, by the way, that handsome guy on your screen is me. That reservation of rights letter that you get might simply say that the claim's in excess of your coverage, and the carrier will then say, you have the right to go hire a lawyer on your own. That's sometimes a good idea, and I'll tell you why in a little while when we get to another issue. Of course, if they accept the claim, then all you need to do is see if you can influence the selection of counsel if you want to. Certainly if you're in an area where I am practicing, my recommendation is you push them my way so that I can defend you. If you are assigned counsel, you should not hesitate to find out what experience that counsel has in your industry, the alarm industry. We're not interested that he's been practicing law for 50 years or 20 years and has handled 1,000 slip and fall cases. That's not a burglar loss claim or a contract claim. The way these cases are defended are much different than how other cases get defended, at least in my opinion. But once they've accepted the claim, you do not need to engage your own counsel because they're going to cover the entire loss over and above your deductible. When there's an excess claim, meaning that the claim exceeds your coverage amount, it is a good idea to engage counsel. I'm often retained for this purpose. And my sole purpose at that point is to make sure that your insurance company resolves the claim one way or another within your coverage. You don't want to risk a carrier saying, we're not paying $1 million claim, we'd rather go to trial, and we don't care that the insured, meaning you, faces exposure of $3 million or $10 million or whatever the claim actually might be. We're not laying out that $1 million now. We'd rather go through a trial. Well, all jurisdictions recognize bad faith by a carrier. If a carrier is able to settle a claim within coverage limits, there are certain criteria that compels them to do just that. And while carriers are sometimes, or even often, within their right to not settle and demand that they go forward with a trial and see where things go, there are other times when they are really can be hard-pressed not to settle the case, and that's when an attorney that knows how to deal with insurance carriers and bad faith issues can make a difference in forcing a resolution of the case before you're exposed at a trial. When defense counsel is assigned and you don't know who they are, again, don't be shy about asking what experience they have. If you don't develop a decent rapport with the counsel right away, then start complaining to your broker. If you use a broker that's listed in the alarm exchange, I can tell you that all of them are experienced in the alarm industry and all of them have a rapport with the carrier. They can be helpful in resolving issues of assigned counsel or getting assigned counsel changed. You need to be mindful of that because especially where you are on the hook for an excess claim, where you're on the hook for a claim that the carrier doesn't want to cover, or where you believe that your time and effort is being directed towards training a lawyer in how to handle this case. That's not what you're supposed to be doing. You're supposed to be attending to business while the carrier takes care of this claim. Yes, I agree you need to cooperate with the defense, but that doesn't mean you need to train them. Your first and best line of defense, of course, is your alarm contract. Probably your insurance company has insisted that you get a proper contract. All of them, at least the ones that have any idea what they're doing, accept the standard contract forms that I offer to the industry. And it's one of the advantages when we talk about defense issues for using the standardized forms. You know what's in them, you know you're covered, and you know you're protected. Also, you know that when I do these webinars, I very often offer a discount, which we are going to be offering today. You know to go online and order your contracts, and if you order them today before 4 o'clock, you will get the discount that we're offering today. And the discount is going to be, we don't have the exact deal. If you buy the all-in-one, you get the other all-in-one, which is, so if you buy sales, you get the lease for half price. And on all contracts other than the all-in-ones, you get a 20% discount today off the contract price. Just fill out the order, put in the right amount, and we'll either put in the full amount. We'll either figure out the discount for you, or if you can figure out the discount, you can put that in. So I'll mention this again later. Again, your order should be placed before 4 o'clock today. I'm now going to introduce our first or second now presenter, and all three of us today that are presenting share a very common characteristic. All of us believe we are legends in our own mind, and we probably are. And certainly Bart, well, I can't say that Bart's any different than Rick, who's going to follow Bart. But we're going to tie in Bart now and turn over the mic to him. And Bart Didden shares a very interesting position in this industry, because not only does he own a central station, but he is the claims administrator for Security America Risk Retention Group. I'll let him tell you about that, known as SARG. And I spent a lot of time on the phone with Bart, and he knows how to deal with these claims, and I'm very happy to introduce him and have him participate today. Bart, are you there?
I'm here, Ken.
Okay, it's all yours.
Thank you. I guess you know, that stellar opening about a legend, and you know, that we share the same opinions. I guess I should say from the beginning that Ken Kirschenbaum is my corporation counsel. We've been together, you know, for some almost 30 years, and you know, my attitude comes directly from him, so it's his fault, not my fault. So, having said that, I think Ken's slides and discussion was really excellent. I want to talk about one or two things before we get to this first slide here. The denial of coverage. You know, recently our company received a filing from one of our insureds about a breach of contract with a vendor of our insureds. If you take actions in the operation of your company, your general liability insurance is not there for that. Your general liability insurance with E&O endorsements happens with the operation of your company with the consumer, or with the locations of where the systems are. It's not there to cover you because you don't like vendor A anymore and you're going to vendor B, and you had a contract with vendor A that you're trying to escape from. So there is a perfect example of a denial of coverage. Ken also talked about the attorney that I hire on your behalf, if you're insured by Sarge. Yes, the duty is to you, the client, even though I'm writing out the check, but I do retain the right to settle, and I do retain the right to approve and oversee the plan of the defense. As an example, recently had a claim. It was for $7,500, not a big claim, $1,000 deductible. And when I was looking at my insured's contract, while it was an acceptable contract, it wasn't a Ken Kirschenbaum contract, but it had all the provisions and it was reasonable. The way that the liquidated damage clause was written, I believe in Ken's contracts it says if you are found to have some sort of responsibility, that's when the $250 comes in. This contract said, you know, sort of like in the event of a loss, and it had a formula, and based on the RMR of the account, the offer, you know, the limitation liability was like $550, and I knew that, you I said, I'm talking with the defense counsel. I said, let's offer them the liquidated damage, even though, it didn't say that it had to be required that we were found to be at fault. But let's offer the liquidated damage of $550, because if the plaintiff took it, one day at court would be $1,500 for the attorney's fees. Ironically and surprisingly, the plaintiff took it, and they said, hey, we also owe the alarm company a service call for $200. Let's throw that in, $750, and we're done. My insured wasn't exactly thrilled, but the plaintiff took it. We settled it, and then to square it up with my insured, because technically it's within, he had a deductible of $1,000, so he should be writing me $550. I waived the deductible, paid the $550 and the attorney's fees, and the alarm company was out nothing. So there's a smart approach to these things, especially when it comes to Sarge, which is a company that's owned by its policyholders and the industry association. And I have an overall responsibility to both sides. So with that, I'll go through a couple of slides here, and then I want to just briefly talk to you about how I select defense attorneys. So here, the slide that you've been looking at, why Security America should be your provider. Industry experience, which I think my comments will bear out today. We understand the exposures, the risks, claims issues. If you never have to call your carrier, that's really great. But, at some point, sometime, and you want to be able to talk to someone that can speak like you. And the board of directors consists almost entirely of industry professionals. The others are attorneys, accountants, and other analysts that we're required to have. So let's move on. What you need to do, Ken started talking about this. Document everything. Call your agent or carrier. Ken said both. That's fine. Find all the paperwork. This is the biggest problem, is tracking everything down. You'd be surprised how many things are maybe misfiled in your cabinets. All of this is important stuff, and it gives me or whoever is working on your claim the ability to get on the phone with the plaintiff and say, did you not remember this contract? Do you not remember that you agreed to these provisions? And it also gives us the ability to set up the discussion with the plaintiff. May be a subrogation case, meaning an insurance company. They paid off on the loss. They're trying to mitigate or reduce their risk, and they're trying to come after you to pay up, because if you got sued, filed on 100 times, 99 would be subrogation claims, and 1 would be directly from a customer. So the paperwork is essential. The next slide. If you're invited to the site, go. Take pictures, take notes, compare the point of entry and the coverage on the site or around that point. Do not overly comment or debate the information you get. They are taking notes as well. Don't sink yourself. Don't be chatty. But if, on the other hand, if the customer says, look, I understand it wasn't you, somebody came in, and you think that you can avoid, depending on the size of the loss, like $7,500. You really don't, in managing your relationship with your insurance carrier, if you can, do $1,000, which is your deductible service call, and add 1 or 2 sensors, and avoid a $7,500 claim and a loss run on your account, It all makes good business sense. So, you know, charge for the service, but you can always waive it afterwards when everybody, you know, is, you know, friendly and working together and cooperative. You'd be surprised if with a little concern will go a long way. And the next slide. Be responsive to the agent and the claims manager. Tell them everything and tell them the truth, because it will come out if later. And some claims are worth settling, some are not. There's always principle, and the reason why I believe so much in Sarge as a company and as a program, not just because I'm involved with it, but we're looking to go out there and set precedents anywhere we can to enforce and reinforce and put more foundation under the contracts. You'd be surprised how many times somebody calls, says, "Ah, yeah, I read that contract. Yeah, you're ridiculous. No court." I said, "You want to know how many courts have upheld that thing? You know, it is reasonable and it's fair based on the fact that we didn't come in and do an inventory. We didn't come in and look at what the value of the property was when we came up with your rates, $24.95 a month or whatever." It's a one-size-fits-all for a service. It's not insurance. So let's move on. Not all alarm contracts are created equal. When you get a notice from Ken that there's an alteration or there's an update, doesn't mean you got to go out and re-sign everybody. But you know what? Every day that you don't get on the next revision is another day that another account or 2 accounts or 10 accounts have gone by, and we'll have something less than optimal. Now, we still have accounts that have contracts from 25 years ago, but essentially, other than the requirement on the three-way monitoring agreement for my company that says that the subscriber has to list me as an additionally insured, everything else is generally the same. Not all insurance companies are looking out for you. We had a claim that Sarge was involved in with a central station and an installing company. Sarge insured both of them, and the plaintiff was Hartford, and then there was another insurance company, Peerless. But Hartford, who writes in this industry, writes companies that may be on this phone right now, they were coming after the alarm contract, and they were taking all the steps in court to knock out the contract. And we're looking, Kenny and I are looking at each other on the phone saying, how could they do this? They have an alarm program, and they're trying to disqualify a contract. You know, these companies are so large, and they're multi-focused, and the left hand doesn't know what the right hand is doing. So that's why I say to you, not all insurance companies are looking out for you. And of course, you know, the plug, only one insurance company is, you know, the one I'm involved with. So let's move on. So what do? Assemble all the preliminary facts, find, interview, and engage the defense counsel. What I do. I'm sorry. I'm trying to catch up on time a little bit. What I do. Finding, interviewing, and engaging the defense counsel. It's a big country. We have insureds everywhere. It's easy here in New York State, in New Jersey. I pick up the phone, I call Ken. Ken, here's an assignment, here's a case. Thank you very much. But in so many other areas of the country, because of the Alarm Association, I call companies that I know, and I say, look, I'm looking for a defense counsel. Don't tell them who or what. I said, you know, what attorneys do you use for your general business practices? You know, it could be collections and mergers and acquisitions, people that have worked with alarm companies before. And then I call them and I see if they have litigation departments, and I'll get a recommendation from the partner. I'll start talking to the attorneys, and just in the last year, I hired someone out of the Phoenix area. Really wonderful guy. He's doing a great job for us. But I also sent them to Ken's website to see the daily posts that we all read. And he was actually out this way for a wedding. He came in and met with Ken. Now, I ended up paying for Kenny's time. The attorney didn't charge me, but Kenny went over and verified the plan of defense that was already adopted. So it's a great resource, and we are very particular on where we're going and how we're finding these defense counsels. I also monitor the progress, including the costs. I supply and or find the technical expertise and expert witnesses. Some of you have heard of Jeffrey Zwern. We've consulted with him on a couple of things. He's great for whoever is paying him. But I like him a lot, and he could really be great if he's on your side of the fence. I'm usually the first person that to ask the plaintiff counsel if he has the contract. I kind of alluded to that before, and that's where Rick talked about it last week. I'm mentioning it again here. A lot of this stuff can get buried right there, right away. So that's pretty self-explanatory, and we'll move on about how to contact us and get next slide, please. Thank you. How to get a quote. It's all about dollars and cents and finding a company that understands what you're doing and can work with you. And I think for the most part, I don't, Ken, anything that you think that from our relationship and working together that you think I've overlooked?
Well, I think you've covered a lot of things from an administrator's point of view, and I do want to comment actually on something that you've said. Some of the other carriers that actually write, and Hartford is number one as far as I can tell, they have a big subrogation department and they sue alarm companies. I don't get it. I don't think they deserve the support of the industry, quite frankly. But that's surprising. I had a recent situation where there's a big claim being handled by Scottsdale, who's representing the insured on a fire loss, and they had not only was the subscriber suing the alarm company for the fire loss, but several adjoining property owners were making claims against the insured, and they were subrogation claims, of course, because they were fire loss claims. One of the claimants against the insured was Scottsdale itself. So I immediately said to the claims rep for the alarm company, what the heck is Scottsdale doing making a claim? We're not defending that. They're not allowed to make a claim against their own insured. And I was shocked when both Scottsdale's rep and their defense counsel said, what are you talking about? Where's your authority for that statement? So we provided the authority for that statement, and that was the end of that claim. I haven't heard from Scottsdale on the claims side on that case, so I guess they figured that out. There is a question here, and I'm going to see if I can call it up. Dealers should pull a panel log of the incident and central station log as part of gathering their support material. That's not a question. It's more of an observation, and it's correct. Panels, of course, disappear after a loss. Sometimes they're not available after a loss altogether because the equipment's damaged. You do want to pull your log, and you do want to get your central station log. Now, let me just emphasize something else here. In this webinar, I did not get into actually how do you handle a claim, because that's really something that maybe alarm company owners don't need to know. Unfortunately, so many claims reps that are involved in the alarm industry, working for carriers, know only one thing. Well, let's move to summary judgment. Let's move to summary judgment. That's all they've heard about. We get out of these cases on summary judgment, which is somewhat true because of the contract provisions. And if you have the right contract, you got a good shot at summary judgment. Of course, it also depends on what the facts of the loss are. And one of the things you need to keep in mind when you are doing your investigation is that you may find out that you actually screwed up. It happens. We're human. The equipment's fallible. That's why we use a contract that says we might, well, it doesn't read this way, we might actually breach this contract, we might actually be negligent in our performance, our equipment may not work, and we're not going to be liable anyway. And the reason for that is, of course, in the security industry, you cannot undertake to be responsible for the loss that may be suffered because either the equipment or your services did not prevent the loss.
You know, Ken, you're absolutely right.
Right.
You know, but wait a minute. You talk about summary judgment. I just want to interject on the case that we had with the Hartford. As the defenses, we were asking that court for summary judgments all along, and we were being denied. And it wasn't because of the law. It's because of the judge sitting on the bench who doesn't understand. Trying to find the right defense attorney is part of it. And then you got to be hopeful that you get a judge that understands the law and can understand the summary judgment, purpose. And in that case, we, when finally,
all right, go ahead.
Well, let me just say that, quickly, in the contract where there was that another plaintiff, another insurance company in the structure that was trying to, get a judgment against the alarm company in Central Station. We went back to Hartford and said, hey, our contract says that you have to indemnify us. They actually went to the court and said, Your Honor, we want a summary motion, denying that we have to give these guys coverage. And the judge turned to me and says, I've turned down every summary judgment request that they've made against you, and now you want me to grant one for you against them? Get out of here. So, sometimes it works out, but other times, don't be discouraged if your summary, motion doesn't come through like you.
Okay, let me comment on that, even though this deserves its own webinar, to be honest with you, and it should be attended by claims reps and defense lawyers rather than maybe alarm companies. But here's the problem with the summary judgment issue. Okay, first, not every set of facts is suitable for a summary judgment motion, and you need to be careful about that. Secondly, the defense counsels that are hired, typically they are house counsel for these alarm companies, or they are defense counsel, and they know one thing. This is how you handle defense. You go through discovery. No summary judgment motions until you're done with discovery. That is the #1 mistake made by defense counsel. The reason they make it is one, they want to run the clock, because you can't make any money if you don't do discovery. It's a lot of time and effort. The problem with doing discovery is you muddy up the water. You bring up all kinds of facts that may not have actually come out had you not done all of this discovery work. One of the things I get quite a laugh out of, I'm sometimes assigned cases from carriers, and before they send it to me, they have engaged an investigator who goes out and digs up all kinds of facts that are harmful to the alarm company. and, you know, thanks very much. When I'm assigned a case off the bat, and at the beginning of a case, and I'm dealing with a new rep, and if the issue comes up, and even if it doesn't, I bring it up. I say, I don't need an investigator. I've got all the experts I need, and the first one is the alarm company that I'm defending. That's who I want to talk to. That's what I want, their opinion on what happened. They're the ones that should know what happened. Bringing in outsiders is the first mistake. Going through extensive discovery is the second mistake. To show you how inexperienced some claims counsel are, I was assigned a case by one carrier, not SARG, I might point out, that as soon as they assigned the case, we moved to summary judgment. And 2 months went by, and they must have told me 10 times, move for summary judgment. And each time I said, listen, I can't move for summary judgment because this case was started with only a summons and no complaint was served. So I can't serve summary judgment motion until I serve an answer, until they serve a complaint and I serve an answer, and then I can move for summary judgment. Well, they just didn't get it. And so that just showed me they don't understand legal procedure and they don't understand how to defend these claims in these alarm cases. Okay, I have to move on because I know that Rick has plenty to say, and he's very experienced also in these cases, representing alarm companies for 30-plus years, I think. And although he's not an administrator for any of the carriers, I know that he has plenty of influence over the carriers that he particularly deals with, and I'm going to let him tell you all about that. So, Rick, are you ready to go? Rick, again? Rick, is this the second seminar that you have gotten lost on? Well, here we go with Rick. Bart, are you still on, or we muted you also? Well, until my staff tries to locate Rick. Bart, you're unmuted, so our audience can hear from you as well, if you're still there.
Yeah, no, I'm still here.
Okay, good. Well, we'll wait to see if we find Rick or not. So Rick was going to discuss how he handles claims. I'll go through his PowerPoint until we find them. My staff's calling him now to see if we can figure out what happened to him. What is a demand letter? A demand letter is any letter that puts you on notice that you have a potential claim. So even a subscriber that writes to you and says, by the way, I had suffered a loss the other day, and just stops it right there. You've gotten notice of a claim. Certainly if they put a demand for reimbursement on it or indemnity on it, then you may recognize it as a demand letter. But any communication at all should be treated by you as a demand. Who do you get them from? You get them from your from your subscriber rather, from your subscriber's insurance company under subrogation, sometimes by third parties. So one of the things that Rick's firm does is he gets very, very involved in trying to squelch a claim right from the get-go. And he apparently has been successful in doing that. Now, what advantage is that? Well, if he can avoid making a claim to the carrier, I suppose it doesn't show up on your loss run, and because as soon as you notify a carrier, they open up a file, and it does go in your loss run history, right, Bart? You're involved on that level. I'm not.
Yeah, typically with carriers, that's true. With Sarge, we'll take notices, but until there is a filing, a more formal document, we don't.
You mean a lawsuit or a claim you pay out on?
Well, yeah, something that once we have to engage an attorney, that's when it hits your loss run.
Okay. So I guess Rick tries to deal with these claims before it gets to that level. He has here on his PowerPoint contracts, and really, why is that important? Because Rick uses the contract terminology to let the claimant or its lawyer know that they are going nowhere with their case. And basically, that's accomplished because of contract provisions, which permits you to avoid liability. I think my staff is anxiously trying to get Rick online. Let's see if we accomplish this. Rick, are you there? All right, Rick's busy dialing in. When he gets here, we'll turn this over to him. Anyway, so Rick uses the contracts.
Hello.
Rick, are you there?
Finally.
We're up to contracts on your power slide, on your power presentation.
I'm sorry, say that again?
We're up to the contracts on your PowerPoint.
Oh, okay. So how long do you want me to speak for?
Well, until I can't stand it anymore.
Okay, well, that's probably now.
Why don't you, you've got 10 minutes or so. Go ahead.
Okay, all right. So real briefly, my agency's been doing this for 33 years. In 1981, just as background, I was one of the 3 founding fathers of the Los Angeles County Burglar and Fire Alarm Association, chaired both the insurance committee and the membership committee, and also sat on the executive board of the association for many years as secretary of the association. And in chairing the insurance committee, I obtained intimate knowledge of the issues with the insurance industry and as it pertained to the alarm dealers, the significance of contracts, why they are so important, how they were defended, and in essence was a cornerstone in developing what alarm dealers now call standard alarm company contracts. So through working with the association, not in the insurance business, but through working with the association and with legal counsel, reviewing scores and scores of court cases, I became a quote-unquote expert in handling these issues. So we put as an association, we put together an insurance program, a general liability and errors and emissions insurance program for alarm dealers, and within 18 months, I discovered that the insurance company, when we would send one of these demand letters to the insurance company, they would open a claim, collect a deductible, hire legal counsel, conduct an investigation, and in essence spent tens of thousands of dollars doing something that didn't need to be done, in my opinion. So I ended up telling the insurance company, once I discovered this, that I was no longer going to send them demand letters, that I was going to handle these issues on my own because they were wasting insurance money giving this to attorneys. And of course they balked at that. And so we settled on an agreement, and it's a business model that I have used for 30 some odd years now, where when one of my clients gets a demand letter from either an insurance company or a subscriber or an attorney representing the subscriber that in essence says, you put a security system in my client's liquor store and they were burglarized and here's what the losses were and pay up or we'll sue you. My clients all know that those letters need to come directly to me. And then what I do is I take the letter, I attach it to a cover letter, and I send it to the insurance company, and that's my obligation to do. The letter says, in essence, attached is a demand letter. I'm going to investigate this myself. Unless you hear anything further from me, consider the matter resolved. And then what I do is I go about handling the demand letter on my own. If you go to the next slide, okay, this is a brief synopsis of my history over the last 11 years, not 33, just 11. It says, dear security professional, a famous college football coach once said, if you can do it, then it ain't bragging, end quote. When it comes to handling claims for alarm dealers, we stand alone. In fact, over the past 10 years, it's now 11 years, we have handled 84 demand attempts, it's now 90, against our insureds, totaling $19,431. And we won every one of them. That means 84 of our insureds did not have to suffer through a lengthy and humiliating lawsuit, pay their policy deductible, sit through numerous depositions, testify in court, or incur a rate increase on their insurance. So we're not bragging when we talk about our success in handling claims. It is our claims to fame. So that's a brief synopsis because of the form that we have here. That's a brief synopsis of what we do. So how do I do this? Let me give you, rather than discuss this, let me give you an example. Here is a letter that one of my clients received from an attorney. It says, "To whom it may concern, please be advised that our offices have been retained to represent West 7 Liquor in the above referenced matter. Kindly direct all future correspondence to this office and not to our client." On July 1st, our client entered into an agreement with your company for installation of an alarm system as well as monthly service. However, on August 25th, less than 2 months after the installation of the alarm system, our client was burglarized and the alarm system did not function at the time of the burglary. As a result, our client suffered a loss of over $13,000 in cash and additional losses in the form of merchandise. Please see attached police department investigative report. The burglars had to break into and open the safe to steal the money inside, and it would have taken a considerable amount of time to do so. Had the alarm been functioning at the time of the burglary, the police or other authorities would have had the time to respond and prevent the burglary. As such, we are demanding a reasonable amount for settlement of this matter at a minimum of $15,000. Otherwise, we have been authorized to bring proper action against you and your company for various causes of action. Further, our client has given you notice of termination of the contract and have contracted with another alarm company for their services. In addition, we demand that Alarm 24 cease demanding further monthly payments from our client for the services that are not being performed. We anticipate a response from you by October 27th. Should you have any questions, yada, yada, yada. Okay, so all being, everyone there being an alarm professional, I'm sure without getting into detail, you could see the issues of this letter. We didn't know whether this, by way of example, I didn't know whether the system was supervised or not, so we didn't know if it was actually set. The fact that there was all this money in the safe would not be insured anyhow, and there were just numerous issues. But the point is, what we're looking at here is what I call a fishing expedition. The subscriber gets burglarized. They get angry because the alarm system did or didn't work, or they're saying, maybe I can get some money out of the alarm dealer. So they call their attorney, and the attorney says, I'll tell you what I'll do. Let me send them a letter, and we'll see what happens. Now, every other agency in the country has an agreement with the carrier to send that letter to the insurance company, and the insurance company then takes over. The issue is that the insurance company has rules that are different from the rules that I have as an agent or a risk manager for my clients. So I don't have to open a claim. I can't deny a claim, but I don't have to open one. But what I do have a right to do as a representative of the alarm dealer is respond to the attorney, with the sole purpose of letting the attorney know if this is just a fishing expedition and you're not aware that there's a contract in place and you're not aware of all the court cases where these contracts have been upheld, and you think you're going to just get an insurance company roll over and give you $25,000 because they don't want to spend the legal fees of $50,000 to go and file a summary judgment, and incidentally, that's about what it runs, then if I could make it go away, I figure, I'm going to win. So I prepare a letter. Excuse me. You can certainly appreciate that after 30 years of doing this, I have scores and scores and scores of court cases that I can, excuse me, I can cite for alarm dealers. So what I do, excuse me, is I prepare a letter on behalf of the client, and I interact directly with the dealer. I'm sorry, with the attorney.
Rick,
Excuse me.
Are you killing yourself here?
I took a sip of coffee.
Well, what? Take a
Okay,
sip.
so here's my response. We are in receipt of your letter. This goes to the attorney of October 20th. In this regard, let me first preface this for a second. One of the things that Bert mentioned is that there was a claim that was handled, and the and the insured wasn't thrilled about it. When I write this letter, the intent is not only to make it go away, but to make the attorney understand why the alarm dealer isn't an insurer. So when the attorney shares the letter in the position of the alarm company, the subscriber doesn't get angry with the alarm dealer. So that's part of the process that I use, and here's the letter. We are in receipt of your letter of October 20th. In this regard, let us first state that we remain very concerned over the alleged burglary that took place at West 7 Liquor. Certainly, we consider any loss to one of our subscribers to be of the most serious nature. The fact that we installed the alarm system at West 7 Liquor only a few months ago, coupled with the large sum of money that was allegedly removed from their safe, causes us great concern. We trust that a thorough investigation of this alleged theft will shed more light on the circumstances of this crime and will bring the criminals, whomever they may be, to justice. So what I'm doing here, and again, what I do is, in this instance, I gave the letter to the alarm dealer, and the alarm dealer put it on their letterhead and they sent it. I no longer do it that way, but this will give you an idea of how we're doing that. So the first thing we want to do is we want to say we don't think that there was a burglary here. We don't believe in that. Paragraph. With that said, and in response to your statement that the burglary was a result of our alarm system not functioning properly, we can only respond by saying your position is unfounded and without merit. First and foremost, it is clear that Alarm 24 was not the sole and direct cause of the alleged loss. The ones who burglarized the store are responsible for the loss. Additionally, and in accordance with the evidence on hand, it is apparent the burglars severed the telephone line when they entered the store. This disconnected West 7 Liquor from our central station, making the transmission of the alarm signal impossible. Had West 7 Liquor purchased a backup system that included a satellite monitor, for example, an alternative signal would have been sent and received when the store was entered. Your client elected not to purchase this service. Further, in response to your allegation that Alarm 24 should reimburse West 7 Liquor for their loss, we refer you to our contract. And then I quote the contract, and I go on to say, the services provided are not based upon the value of the premises of the contents they protect, but rather on the value of the alarm system itself. And then I quote some court cases. And here's one that I quoted in this one, where the judge said, quote, no reasonable person would expect that the proprietor of alarm service would, for a fee unrelated to the value of the property, undertake to provide an identical type of coverage should the alarm fail to prevent the crime. In essence, and I'm not quoting here now, but what we're saying here is that we're not charging you for insurance. We're just charging you $25 a month. Whether we've got an alarm system in a liquor store that has $100,000 worth of inventory or $1 million, it's still $25 a month. The letter goes on. Alarm companies have on occasion been liable for negligence. However, were an alarm company to be held responsible for losses that should be covered by insurance, then no alarm company could possibly remain in business based on the fees that they charge. That, of course, is the reason why people and businesses purchase their own insurance. Courts throughout the land have universally upheld the liquidated damages clause in alarm company contracts. The following cases will provide you a good indication of how the courts have rendered their decisions. And then in this letter here, I cited 4 different cases. Now, technically, the attorney would have to research these cases before he moved forward with filing a lawsuit. So now we're running up the bill for the alarm dealer to pay his attorney to, I'm sorry, for the subscriber to pay the attorney to have him review this. Letter goes on. While Alarm 24 does have a contract with West 7 Liquor to provide security services, these services do not include insurance. In fact, the language in our contract specifically states we are not an insurer. The agreement further states that should we be found liable for a loss, our liability is limited to $250. Considering the circumstances of the alleged burglary, we do not see where there is any liability on our part. We trust that after you read our contract and review the above court cases, you will agree with our position. In closing, you have asked that we cease demanding further monthly payments from West 7 Liquor. Again, we refer you to our contract. The verbiage in the contract regarding the term and monthly charge is clearly detailed. Therefore, we suggest that you advise your client of their responsibility in this matter and encourage them to bring their balance current. Should they choose to ignore the agreement, we are prepared to enforce the terms of the contract to the fullest extent of the law. If you have any questions, please feel free to contact us. We got a letter back from the attorney. They continued the service. They dropped the claim, and they went about their business. So this is how we do it. If you look at the next page there, you'll see that there are some very large cases there. The largest was $3 million. Briefly on the $3 million one, it was a jewelry heist. The central station, in fact, dropped the signal. It was ugly. I sent a letter explaining what the contract said, explaining that we didn't cause a burglary, and yes, we may have made an error in not notifying the police department when we got the second signal. They did notify the RP when they got the first signal, but not the second signal, and they were instructed to do that in their conversation with the RP. Nonetheless, after the demand letter, the jewelry store owner turned it over to Fireman's Fund. Fireman's Fund paid the claim, and then they initiated subrogation against the alarm dealer. And I handled the subrogation, again, without any participation of the insurance company whatsoever. We got into a email battle back and forth that went on for about 3 or 4 months, and I used this case in seminars. And finally, after me denying any obligation on the part of the alarm dealer, I got a final letter or email from the attorney representing Fireman's Fund, and it was an in-house attorney. And the email said, "Dear Mr. Gumbar, I am responding to your last email where you have steadfastly refused to accept any responsibility whatsoever on the part of the alarm dealer. What surprises me most is the fact that you have consistently neglected to mention the $250 liquidated damages." So it went from $3 million to $2.5 million to $250. What I did was I didn't send them the $250, if you want to know. What I did was I sent them a letter saying that I was unable to speak with the alarm dealer, but that if they would send me an unconditional release form on the claim, I would be more than happy to personally guarantee the $250. So the important thing is that these issues do not have to, if it's done properly and you've got a good contract, it does not have to get in the hands of the insurance company, and it does not have to get into a summary judgment or a cost of $50,000 or more by your insurance company. If you have a risk manager and the risk manager knows what he's doing and he knows how to attack these, they are winnable. Attorneys are very often just out to extort some money from an insurance company. Insurance companies have a history of saying, we can give this guy $25,000 to go away, or we could pay $50,000 and argue for summary judgment in court. The thought of of using that process, it becomes pretty obvious that you'd rather spend the $25,000 just to make it go away. But it sets a precedence. So what I do is, in handling all of these, is I let the attorneys know, listen, here's all the cases that we have won. See if we're going to roll over. We're not. And I can tell you, to make this go faster, because I know we're at time constraints here, that I've handled close to 90 of them now in the last whatever years. Over 33, God knows how many I've handled, but I'm up to 90, and it's almost $20 million. And I can tell you that 2 attorneys decided they weren't going to accept what I said, and they filed a lawsuit. and I oversaw what the attorney did. I have an attorney that we use that is intimate with the security industry. Matter of fact, she knows how to install alarm systems. She's intimate in the industry, and I use her a lot. I also use Ken, as you could well imagine. But in this case, I used a California attorney, and I walked her through exactly what we wanted to do and how we wanted to approach this, and she applied for summary judgment, and we won both cases. Legal costs were between $30,000 and $40,000. It took close to a year to get it done, but it got done. The important thing is that the vast majority of these cases can go away if, number one, you use good contracts, and number two, you give me something to fight with. Because if I can fight and discourage the attorney to go away, you end up with no claim on your loss run, you end up with not taking depositions, you end up with not tying up your own alarm company, and it's a win-win for everybody. And that's my spiel, and I'm sticking to it.
Rick, thanks so much. That was a great presentation. I do want to point out to everyone that Rick, acting as an insurance broker, it does go above and beyond, so don't expect whatever other broker that you might be using to get involved the same way Rick does. It's just not a role that is typical of an insurance broker, and Rick has a unique experience and history in this industry, and that's why he's able to do it. Defending cases and how they're defended, I think, is a separate issue that we're going to address in another webinar, because it is an interesting area, and I guess giving some information to alarm dealers what they should be expecting from defense counsel and what they should be expecting from a lawsuit if one gets filed, or how a matter should be resolved by a carrier. It could be an interesting topic, although I don't want to give too much information to something that you don't necessarily need to be an expert in. You need to be an expert in the alarm industry and installing and servicing, etc., but not necessarily how to be a lawyer. That's why we go to law school and spend a great deal of time in these areas. I want to conclude by letting you know that I know you might think I cry wolf with these alarm sales, but this is it for this deal. And we do have 2 more webinars already scheduled where, I don't have them in front of me, but one is on technology. I think that's next week. And that's going to be a great presentation. There are going to be 5 presenters. It's going to be about, yesterday's gone, tomorrow's here, so they're going to be discussing new technology. And then on August 8th, we have another webinar where we're going to be, we have 3 presenters, and they're going to be dealing with marketing your alarm industry and some ideas for your alarm industry. And we had 7 webinars in this schedule that I created in July and August. And I guess to some extent, one way I could look at it is, thankfully, August 8th is the last one scheduled at the moment. And I'm happy to schedule others. We need some ideas. If you guys want me to schedule stuff, just let me know, and we'll put together the experts for you. And if Rick's one of them, we're going to teach him how to log in so that he can be ready to roll. At any rate, I want to thank you. We had a great attendance today. I hope you got something out of it. I hope you take advantage of today's sale and save money on your alarm contracts. Trust me, you need them. The foundation of your defense. If you listen to what Rick talked about in his letter, what he was saying in essence is, our contract provides us with protection, insulation from liability, and even if we were negligent for some reason, we're not responsible and we don't have to pay your claim. That argument comes from only one place, your contract. In the first instance, it needs to be properly drafted. In the second instance, it needs to be properly executed. In the third instance, you need to be able to find it when the claim comes in. So those are three elements you need to keep track of. But today, we're starting with number one, get the contract. Then we'll deal with getting it signed, and then maintaining it and keeping it. Yes, you can scan it, photocopy it. You can have copies. They're useful. They could be used as evidence in a court of law, but that also is a different topic. So today I want to again thank our presenters, and I want to thank everyone who took the time to listen in, and see you around.